Thank you for the opportunity to testify before you today. As has been said, my name is Diane Black, and I am privileged to have the honor of serving in the House of Representatives on behalf of Tennessee's 6th Congressional District. Prior to entering public service, I built my career around the healthcare sector as a registered nurse. My career began as an emergency room nurse, where I spent the majority of my career, but I have also worked as a long-term care nurse and part of an outpatient surgery team. I decided to run for office after I witnessed firsthand how poor public policy was directly impacting my ability to deliver health care, and more importantly, the unfortunate outcomes on the lives of my patients. Today, I'm here to share with you, as a colleague in the House and then also as a mother, a grandmother, and a nurse, my grave concerns with the chairman's legislation. Although called the Women's Health Protection Act, this bill would nullify and declare unlawful any law at any level of the government, whether federal, state, or local, that presents what the bill deems to be an undue burden on women seeking an abortion. This legislation would effectively overturn the majority of state laws regulating abortions. As a nurse, I can tell you that abortion is unlike any other medical procedure. This is an act that does not just involve the mother, but the child. It takes the life of an unborn child and in the process imposes many serious medical risks to the mother. To be clear and transparent, I am unapologetically pro-life. And while I believe that the life of an unborn must be protected, I also believe that we must do everything in our power to protect any woman who decides to have an abortion, even though I may disagree with their choice. During my time in the ER, a young woman came in after having complications with her abortion, which had been done in a clinic that was not regulated properly. When the complications occurred, there was no answer at the after-hours number that she called. And by the time she reached the hospital, she was dying, and there was nothing that I or the doctors could do to save her life. As a result of an abortion, the young woman lost her precious life. Her life could have been saved if proper regulations had been in place that protected her health and the well-being, and that held the abortionists accountable. Now, infections occur 1 to 5% of the abortions. Cervical lacerations, incompetent cervix, and other injuries can occur to the cervix and other organs during the abortion procedures. Worse, minors are up to twice as likely to experience cervical lacerations during an abortion, and overall are even more susceptible to short-term risks than are older women. Women who have had abortions are at a 37% increased risk of preterm birth in subsequent pregnancies, a 30 to 50% increase of placental previa in substantial pregnancies, and 18% more likely to develop breast cancer as opposed to the average of just 12%. In the case of women with a family history of breast cancer, this jumps up to 80%. Abortions not only pose serious physical risks, but endanger a woman's mental health as well. Studies show that after having an abortion, a woman is 81% more likely to develop a mental health issue, is 37% increased risk of depression, 110% increase of alcohol abuse, and sadly, 155% increase in the risk of suicide. After the horrific case of abortionist Kermit Gosnell, Americans know that even though abortions are legal, these are procedures that are risky and must be regulated. Perhaps that is why 39 states require that abortions be performed by a licensed physician, and why 26 states require abortion clinics to meet the same clinic standards as ambulatory surgical care clinics. And just as important, 42 states prohibit abortions after a certain point in the pregnancy, and about 9 prohibit abortions at 20 weeks, or at the start of the 6th month of pregnancy, when medical research affirms that unborn children can feel the pain during an abortion. We are, after all, discussing a medical procedure that ends a human life. Let us not also forget that the Supreme Court indicated in Planned Parenthood versus Casey that the government has an interest in preserving fetal life. Senate Bill 1696 represents a sweeping attempt to undermine dozens of measures enacted by states to protect women, all under the false pretense that abortions are safe and rare. My hope today is that we can reach across party lines, realize our preconceived notions on this topic, and see abortions for what they really are. Abortion is brutal to both the mother and the unborn child. It is not health care. To reference the Supreme Court, a dilatation and extraction abortion, which represents the majority of abortion procedures in America, is a generally gruesome as part of a partial birth abortion. These abortion procedures are the most common for abortions performed in the second trimester of pregnancy, where the unborn child is literally torn apart limb by limb. In considering this and many health care risks that can occur as a result of abortions, I strongly urge you to reconsider advancing Senate Bill 1696 and any other effort that would undermine current laws that exist to protect the health and well-being of women and unborn children at the federal level, state, local government level. Thank you again for the opportunity to be here today, and I yield back.